Welcome back from that munificent lunch. It is my distinct pleasure to have the opportunity to introduce Bob Stack, who is going to be our speaker. Bob is Deputy Assistant Secretary for International Tax Affairs in the Office of Tax Policy at the United States Department of the Treasury. He's responsible for conduct of all matters relating to international tax policy, tax treaties, representation of the United States in international organizations, dealing with other branches of the government and other executive branch agencies. In that capacity, he is, of course, U.S. Delegate to the Committee on Fiscal Affairs of the OECD. And I would say in this regard that he has been, as I said earlier, a constant and I think heroic participant in the unfolding of the BEPS project. Quite apart from that, Bob spent a great deal of time, more than 25 years in private practice, and he is truly one of the outstanding international tax professionals in this country. So without further ado, I introduce Bob Stack.
Thank you, David, for the kind introduction. And one of the nice things about practicing international tax law in Washington is it's a community where I've certainly benefited from lots of time and discussion with David on important issues and a kind of a feeding back and forth of how we grow in these various spaces. In fact, the 385 regs were David's idea, and I want to give him credit for that. Okay, that was a joke. I spoke here 2 years ago, and I gave this speech at this conference, and I used a phrase about the OECD getting the tax administrations wanting blunt instruments in order to basically rein in taxpayers around the world. And I flew that evening to Paris for the OECD meetings, and that was one of the several times in which I would arrive in Paris to be told that people were very, very angry that I wasn't towing the OECD line. And more interestingly enough, my French-speaking colleague, particularly Pascal, didn't know what a blunt instrument was, so I had to kind of help him understand that so that he could get the point. Not much going on in international tax. I really had to kind of scrape around for what to do today. And as much as I know we're interested in 385 and inversions, I do feel something of a civic obligation to talk to American audiences about the international environment, at least I want to start here, in which I operate as the U.S. representative abroad. You know, people said in the past, this particular job, the Deputy Assistant Secretary of International, might have been doing the treaties, might have been doing the international regs, and now the issues flow by us so fast, it's really, I have to say, sometimes challenging just to keep up. But I do think one theme I want to share today, and I think as I walk through these things, is the degree to which the U.S. tax policy debate often takes place in a rather myopic space, or from a myopic point of view. And I think, you know, if I dove into 385 and inversions, I'd be really proving the case that because I'm in front of all these talented technical tax lawyers and accountants, that the most critical issues in international tax relate to the United States' most recent regulations. But I spend an enormous amount of my time and energy in the international space, and I want to walk you through some of that today in terms of context. Because I don't think the United States tax community, I do not think the United States business community is sufficiently engaged in the global agenda setting in tax. And I don't think it's enough anymore to simply look at the US Congress or even the US Treasury as the font of all international tax that affects your lives and your practices. And I'll begin by just talking about the G20. I was explaining to someone yesterday, I'm virtually certain that before I came into government, I suspect I was vaguely aware that the G20 were the top 20 economies by size in the world. I may have been aware that they meet from time to time. I certainly was not aware that the finance ministries get together 3 or 4 times a year and put out a communique, and I was less aware that the leaders meet annually and put out another communique. But the G20 is a critical driving force of global international tax policy. It is something I pay extraordinary attention to in great detail because it will trickle down into US tax policy one way or another at one time or another, and I'll give some examples of that. Stepping back, even outside of tax, the driver of putting together the meetings of the G20 related to the fact that before these countries got together as regularly as they do to talk about a variety of topics, whether it's banking regulation, environmental, tax, fighting tax, illicit flows, terrorist financing, and the list goes on and on. I've been told that, countries barely knew each other at this administrative executive level. So if there was an Asian financial crisis, people at US Treasury kind of struggled to figure out who does one talk to and how about things happening in that other country's economy. And so the G20 meetings became a way to bring together the world's largest economies to talk about issues that cut across economies in these broad areas, do some standard setting, hold each other to account, and drive various agendas. And one of the agendas that have been in this space since I had my job and since before were elements of the international tax agenda. And I need give no better example than the fact that the OECD BEPS project grew out of a G20 leaders communique in June of 2012. And I've heard an enormous number of people say when the BEPS project took off, they expected another kind of sleepy project putting a bunch of things on the shelf that would be ignored. And now I've heard a great number of people saying that was not the case. In fact, it had an enormous, will have an enormous global influence. And that relates to the importance of the mention of base erosion and profit shifting by multinationals in a G20 communique in 2012. More recently, for example, the G20 has asked something called the Global Forum on exchange of information, on transparency and exchange of information for tax purposes, what we just call the Global Forum, that monitors information exchange among countries on request. The G20 asked it to monitor the exchange of information automatically, which relates to FATCA and the globalization of FATCA through the CRS. Now, the effect of asking an institution like the Global Forum to monitor us is that at some point they will have the standards, and at another point, countries that do not satisfy the standards of the Common Reporting Standard may well be identified and called out for this kind of global world pressure. And I'll come back to it later, but this is an area where countries do not like to be singled out in a communique for not going along with the global standard, not least because the United States is trying to set global standards that we want other countries to go along with, and it's just harder if we're not living up to obligations and commitments that the rest of the world is making. So it's a remarkably important place. If you want to follow where international tax is going, take down those finance minister communiques and the leader communiques, read them. It's a little bit, there's a lot of inside baseball in the language, but once you're in the club, you kind of realize what's happening. But it's very predictive of where things were going. I was just looking back at similarly with the G8, I was looking back at the 2013 G8 communique, which talked about country-by-country reporting around the same time BEPS was starting. And now, 3 years later, you're seeing the EU mandating public country-by-country reporting. And I think it behooves us to be watching the global debate and seeing how it goes. Now, last week, just to finish in on that, in the communique, what were the topics that were prominently fleshed out? Well, there were the BEPS topic, which has been regularly in there, and now we're about implementation of BEPS, and I'll come back to that. There's an inclusive framework that's going to bring even more countries into the BEPS orbit by having countries meet to set standards, think about implementation, refine some of the guidance that's been given. There's always a section on the automatic exchange of information, which is FATCA, and the creation of the Common Reporting Standard, and a desire to have all countries move to it and adopt it. There's always developing country tax issues, and here too, I spend more time on developing country tax issues than I ever would have imagined, but I will tell you two things about those issues. Number one, it's a space in which the NGO community plays very heavy, is very strong, and many of the ideas that begin in that developing country space percolate up to the developed country space and become tax policy issues that you all start to see in your practice. And country by country reporting, by the way, is an example of that. And now, the last thing that popped up in last week's communique, it's been there a while, but the Panama Papers gave it an extraordinary extra impetus, is the concept of beneficial ownership of entities and accounts. And this began to take on new urgency at the G20, and you're going to see greater pressure on transparency, not just with respect to accounts and tax evasion, but when you get up to the political level, questions of transparency for individuals get easily conflated with questions of transparency for multinationals, and you can imagine an acceleration, for example, in the push for making various elements of beneficial ownership public in the company by company space, and greater debates on the beneficial ownership issues greatly. Now, these agendas are certainly pushed by tax policy makers, but I think maybe it shouldn't have surprised me, but what has fascinated me anyway, as somebody coming from the outside into government, is the degree to which events propel these issues through the system. And I don't think one could underestimate the at least short-term impact that the release of the Panama Papers has on the issue of transparency and pushing forward issues of beneficial ownership. When you have an event like this, one of the first things that happens is the ministers demand deliverables and new actions and greater something or other. And so even though those of us who are tax professionals, we could tick off 6 reasons a Panama company may be fine, it may be criminal, it may be somewhere in the middle, but all by itself, the fact that there's X number of papers or X number of entities, I think as tax professionals we know doesn't really tell us much. But it has told the world to get in gear for pushing forward on transparency, and you're going to be seeing, I think, news of that every day. So I think that US tax policy takes place much, much less in a vacuum of what one party in Congress thinks or even what the Treasury thinks. It's a constant part of my job, and C/C is a good example that we're there now, in part because of the international push for it. And even something like transfer pricing documentation, where every country is going to have a particular approach. We are at the OECD BEPS project. We put together a package on how to do transfer pricing documentation with a local file and a master file. And that's kind of a good example of a globalization that has very strong pluses and perhaps some trade-offs. The pluses are that the multinational community didn't want to face 150 different local transfer pricing documentation obligations, and the countries wanted more information. And so sure, you get criticized, I get criticized because, for example, the master file requires things like financial statements of private companies, which up until now have not necessarily been given to tax authorities. But at the same time, the multinational community with whom we worked wanted to get some standardization in that space. But these are really both 2 examples of international forces shaping tax policy here in the United States. The NGO community, as I mentioned, is an extremely strong presence in all of these debates, And I've been commenting recently in my public statements that it appears to me, from where I sit in so many venues, that the multinational community, somewhat ironically, given their heft and their importance in the global economy, seems to be almost absent from setting the global international tax policy debate, whereas the NGOs are extraordinarily strong. And I'll give you an example that just happened this weekend. There was a panel at the IMF spring meetings that Christine Lagarde participated in, and Nobel Prize-winning economist Joe Stiglitz. And for the first time, I heard the NGO community latching on to a minimum tax as something that could be beneficial to developing countries. And I actually think that's right, personally. And why is that? Well, because if US multinationals knew that if they shifted income out of poor countries into tax havens, it was going to be subject to some minimum tax rate in the United States, it takes the pressure, it takes the benefit out of stripping out of the poor country off the table. And if the United States and Europe, the home of the residence countries, adopted similar policies, this could be extraordinarily beneficial to the developing countries. And it was the first time I've heard it pushed in the NGO community as something to help developing countries. And as I mentioned, the developing country agenda is often the incubator for ideas that get greater acceptance, perhaps when it's too late for all you folks to realize what's happened. And I simply point that out as another thing to watch. So let me circle back in on just a couple of the in-depth on some of the issues that again, were framed in the G20 place. And I'll start with BEPS, and I'll give you a very quick highlight of kind of what's coming up in the BEPS space. I think among the most critical things about BEPS is working on implementation of the BEPS deliverables. And the most critical element of implementation is putting into effect the four things that countries agreed on as so-called minimum standards. And the four minimum standards, the first was around country-by-country reporting, which you know we've proposed regulations, other countries have. There's a problem at the moment of the different years, and we're working on seeing what we can do to, both with countries and within the United States, to kind of smooth that over so we have a smooth start to country-by-country. There's a minimum standard with respect to treaty abuse. The United States already has a limitation on benefits provisions. The concept here was when a country goes to negotiate a treaty with another country, that other country, now as a minimum standard, must permit the first country to insist on a provision to protect its tax base, or I should say protect against treaty abuse. The United States uses limitation of benefits. Many other countries now are going to move towards a principal purpose test, whereby if the principal purpose of the use of the treaty was to get treaty benefits not intended, or some standard that we've complained about is too subjective, then the country giving the benefits can deny the benefits. We will see that incorporated in treaties around the world one way or another. The next minimum standard related to improving the mutual agreement procedures, because one of the really important things was that countries are putting the right resources into MAP cases, that they're settling them on a principled basis, that there's some transparency. You know, how many MAP cases does this country have? How old are they? How are they doing? That there's some taxpayer input so we can hear from taxpayers about bad practices of different countries in the MAP place. And that work is going on to kind of fashion the standards for a MAP process and setting forth a peer review process so countries can kind of review each other's compliance with both the spirit and the rules surrounding MAP. And the last one relates to harmful tax practices. And here I would just highlight that it was really the harmful tax practice work that drew in or put an end really to the UK patent box that did not require any particular research and development to be done in the country before, but on the same time, people could get benefits of taking royalties, let's say, into the UK, get them taxed at 10%, but get 25% deductions out of Germany with doing very little but moving paper into the UK. And that was the type of work the Forum on Harmful Tax Practices does. But much more important in this space is countries have come together to agree to exchange rulings. So the LuxLeaks event, another big event, put a focus on the fact that countries were giving rulings that were advantageous, that if the other countries that were affected by the ruling had the ruling, at least they'd be tipped off to the fact that there might be some tax avoidance going on. And now countries have agreed, as a matter of course, to share rulings that affect cross-border tax flows, and the United States will do that as well. That does not involve bilateral APAs, but it does involve other rulings that might affect cross-border, which I don't think is a huge, I don't think this particular one was aimed at us. A couple of other points while I'm on the BEPS project. I think we're going to see the work on interest. The UK has already either introduced it in its budget or enacted it, I'm not sure which, but you know, that was the provision that really lowered the deductibility of interest to the 10 to 30 range, and at the same time gave countries an option to have a leverage prove-out. Here, the concept was that a country's internal debt deductions should not be greater than their deductions related as a group to external borrowing. And so then the question became, you set limits around the world, but if a company were to have leverage outside greater than that 30%, then the company can come in, show that, and actually get to have a greater interest ratio in the home country. And that is similar to the US budget proposal, although we used a less generous 10%. I think you'll see the work on hybrids. Again, I think you'll see countries adopting the hybrid work, which reached an unfortunate 400 pages. The other things are the attribution of profits work will continue this year. I mean, we were upset about changing the definition of PE without having some broader agreement on the attribution of profits. I think part of the problem in this space is the number of countries that do or do not adopt something called the approved OECD method on profit attribution. So I'm not 100% confident that this work is really going to provide the clarity that we thought would have been necessary, but that work will continue. And then finally, the United States is a big proponent of mandatory binding arbitration in treaties. Not because we want to arbitrate cases, but the theory is if you have arbitration provisions in a treaty, it creates a kind of a better process up and down the chain of administration if the people know that at the end of the day, an arbitrator is going to pick between two offers one offer from each country. And you know, this is one where India is not interested for now in doing it, but we do have about 20 countries willing to move forward on arbitration. And we're working on that. And some of these items will be in a multilateral instrument that the OECD is negotiating and working on this year, so that countries do not have to amend everything on a bilateral basis. Whether there's a reason for the United States to sign that multilateral at the end of the day will remain to be seen. We already have LOB, we already have partnership look-through rules in our treaties, we already have arbitration in our treaties the way we like it, it simply is going to remain to be seen. On transparency, which is I think the next wave, the next thing, you're going to see an article every day on transparency. The first thing I want to point out is in the United States FATCA agreements, you may recall that the way FATCA got implemented around the world is as follows. The FATCA said to financial institutions around the world, if you're not willing to do some due diligence, find out who your US account holders are, you, Mr. Financial Institution, are going to suffer a 30% withholding tax on every nickel, on every investment you're getting out of the United States, interest, dividends, et cetera. Well, that gave the financial institutions of the world an impetus to come on board with FATCA. But guess what? Those institutions said, well, wait a second. We just can't tell the US government or any third party who our account holders are and turn over that information. So we had a bit of a glitch. And what happened, and my predecessor, Manel Corwin from KPMG, gets enormous credit for this, they went to the countries and said, okay, how about you make your law, the law that requires these financial institutions to give you the information about U.S. account holders? Whereupon the country said, fine, but we want something. And the something they wanted was they wanted to know about their residents in the United States. And we said, in many cases, fine, we will do a reciprocal agreement if we're convinced that you have the policies, processes, and procedures and computer technology to take information in and keep it confidential, and we trust you to use it for tax purposes. And if you have a society that has sufficient rule of law, that it's a good judgment to let that country have a reciprocal agreement with us. But what can IRS give the other country? Only what it collects. And while, as you know, the IRS collects information on dividends and interest from financial institutions and the like, there are some things we get from foreign financial institutions that the IRS doesn't get from financial institutions here. And the two most important ones are the IRS does not learn the full account balance in a financial account, and it doesn't learn who are the owners of entities that hold passive assets. So if a Swiss person comes here and opens up a U.S. corp, and in that U.S. corp is a bunch of stocks and bonds, we don't, as a tax matter, require that entity to tell the financial institution who the owners of the entity are, and we don't require the financial institution to report it to the IRS. So we are not fully symmetrical in FATCA the way, with the same type of information that we receive under FATCA. And I wanted to draw out on this today some, is because in the current wave of transparency, more and more countries are going to be asking, why is the United States not compliant with the very standard that it has sold to the rest of the world? And in the last 3 Green Books, I think it's 2 or 3 Green Books, the United States, our administration, has put forward a statute asking to have this type of reciprocal information that can go to the IRS and to the other countries to make our deals fully reciprocal. And it's this kind of international standard setting where we might, for example, be viewed as the rest of the world as not fulfilling commitments we're asking others to make, which also makes it more difficult for us to go to other countries and ask them to also meet global standards that we would like to be setting. So I think we're going to see more in that space. The second thing that I'll point out in the area of transparency and tax evasion is we have 8 tax treaties pending before the United States Senate, which has not ratified or given advice and consent to a treaty since 2010. 3 of those treaties are particularly important in the space of tax evasion. The new protocols with Switzerland and Luxembourg make it easier for the IRS to obtain information that is foreseeably relevant to U.S. tax audits from those countries, and ratifying or giving advice and consent to those treaties would also aid us in this tax evasion debate. And finally, there's the Multilateral Convention on Mutual Assistance in Tax Matters, which is kind of like a global TIA, so you have more countries that you're in this tax information exchange with. I mention these today because I do think we're going to see additional emphasis on the transparency issues on where is the United States. And the final one I'll mention is on March 30th or 31st, we announced that we will very soon propose regulations to require the foreign owners of U.S. single-member LLCs to acquire a tax identification number and essentially treat the U.S. single-member LLC as a corporation for purposes of 6038A. And why is that important? Because in the absence of that identification of the foreign owner, a foreign person was able to establish an LLC in the United States, and if the asset in that entity was, let's say, a foreign bank account or stocks and securities in foreign countries, when another country came to the United States and said, hey, we're doing a tax audit of Mr. X, can you tell us who the owner of this LLC is? We were not able to do that. And in that sense, we were falling down on our obligations on beneficial ownership. It puts the United States in a funny position to be calling out Panama for weaknesses on the beneficial owner space and not necessarily getting our own work in good shape as well. So I wanted to just run through where we BEPS. I left out one thing on BEPS that I feel very good about in terms of going forward on BEPS. One of the things I've seen in my job was a disconnect, if you will, between revenue authorities and finance ministries around the world. It's the more time I spent with revenue authorities, the more the light bulb went off that revenue authorities are interested in one thing: revenue. And what they're not thinking about is, well, what are the right ways to attract foreign direct investment into our country? You know, India wants to move up the chain of countries that are easier to do business in. But are they making the connection between the ease of doing business and some of the tax stories that some of you might encounter in doing business with India? More broadly, finance ministers from countries would come in the United States. They go to meetings with U.S. business, and they say, we want more foreign investment in the U.S., but seemingly completely unaware of just how difficult, perhaps unprincipled, perhaps time-consuming, dealing with the tax authorities in those countries are. So we went to the G20, now trying to use the G20 space to affirmatively help both global growth, multinationals, building on principles. And we said, don't we need to do a work stream on the importance of better certainty in tax law, whether it's the laws, the policies, the administration, and concepts of global growth and foreign direct investment. And the Chinese, who are the current president of the G20, agree that that's a good work stream. And the Germans, who are the next president, want to take it forward. And they've agreed in the July finance ministers meeting to have a symposium in which Secretary Liu will participate to talk about and raise up these issues of the critical relationship between tax certainty and investment. And then the way the G20 works, we hope we can put this on a path going forward and have gotten a little off defense and a little bit focused on things that can help us going forward improve the global tax environment. So let me end with just a couple of words on 385 and inversions. I guess as I was thinking about today, I was going back through some of the Treasury stances on these two topics. And I wanted to stress something that I feel very strongly about. And that is, it's Treasury's obligation to protect the U.S. tax base. That has been our stance in BEPS, whether it was about principal rules, whether it was about PE rules that were not going to take away the U.S. tax base and give it to foreign countries, whether it was about our going on offense on the digital economy where other countries wanted to make it easier to tax our companies. That has been our stance in the state aid cases, whether it was about taking money that we think Europe has no right to tax and taxing it in Europe, for which there'd be a foreign tax credit. And that has been our stance with respect to the rules on debt and the rules on inversions. With respect to inversions, the Secretary has repeatedly said that we would use whatever administrative authority we have to stop inversions, but that only Congress could act to end inversions completely. And we have said we continue to look. The administration, we continue to look at other ways that inversions are happening and what our authority might be in that space. We have put an emphasis on business tax reform as a way to make our tax system better, more stable, and keep companies here. But I do want to have a word of warning. There are folks, I believe, that will use the inversion debate to make the argument that we should not be doing, let's say, revenue-neutral tax reform for business, but that we should be doing revenue-losing tax reform in the business and corporate space. And to that, I would simply ask whether the logic of that is that the way we will ultimately stop inversions is to join and win the race to the bottom until our rate is the same as the Irish rate. Now, you may applaud that as a wonderful corporate tax policy. But if you do, you also have a responsibility, I think, as Americans, to answer the question, where the revenue comes from to have budgets that are reasonably in balance and that can meet the long-term fiscally responsible goals of us as a country. And as I said to business groups, I'm a little fascinated by the fact that I get lobbied by people that say, I want to pay less tax, which shouldn't surprise anyone. But when you're in the government, your job is to make the receipts bear some resemblance to the expenses in a responsible way, and the administration has tried to take that view. So we do need to reform our tax code to minimize the incentive for inversion, and I won't go all the way into the elements of our business tax reform, but I will say that the answer to inversions is not to join the race to the bottom so we have ultimately a zero corporate tax rate without having the way to get that revenue so we can do the things we need to do that are fiscally responsible. You know, on earnings stripping, let me just say this. I think that I've said in the past, I might have said it here 2 years ago, I forget, but one of the almost comical things in this whole BEPS debate is, you know, you get the UK DPT, this extraordinarily complicated device to stop, from the UK's point of view, money artificially flowing out of the UK. And that's because US highly engineered structures or other engineered structures out of these countries need these kind of very complicated devices to combat them. But in the United States, if you wanted to strip income out of the United States, I think we made it easier than any country in the world. You just had to dividend a note. It wasn't too hard. You didn't need any sandwiches or double this or double that. And I think it was that particular phenomenon, and I'm very interested to see in the reporting since our regs came out, the number of firms and professional writers who acknowledged that this was a commonly used technique. And we saw that phenomenon and we looked at our authority under Section 385. And as I said earlier, it's our job to protect the fisc. And we went back to first principles and we asked ourselves a question some of you have probably asked in practice. What is the difference between debt and equity when a wholly owned entity dividends a note up to its parent? And I think to our credit, we answered that question, not just in the case of inversions or in the case of stripping out of the United States. We looked across our authority and we said, you know, if we think that the mere issuance of a note in a circumstance in which it typically doesn't look too different from equity exists in this space, it looks like it exists across the space, and we applied it broadly in our 385 regulations. I would add that some of the, quote, complexity that we see, if you follow them through when you finally work through the rest of the regs and the examples, you're going to see they're really all variation on a theme. And the variation on the theme is just moving notes through a group, either for stock or assets of your affiliates, that do nothing but shift debt into a place where there's going to be more advantageous to take deductions. Now, this idea wasn't like something we all just sat around and thought about. There's a Kraft case in the 50s, and the court was asking the very same question. The taxpayer won the case, and the majority said, well, you know what, it's got the bells and whistles and the creditor rights, and it's got a term, so we'll call it debt. Fair enough. But then when Congress came along in 385, it threw up its hands and said, you know, these court cases are all over the place. So we're going to ask you, Treasury, go in, look at specific circumstances. You're not limited by, you know, particular elements that have been highlighted in the courts, and help us distinguish debt and equity. And I think that's what the 385 rules do in the -3 space. And in the -2 space, it says, if you really want to treat your affiliates as separate entities to respect the debt, how about a piece of paper here and there that is a type of piece of paper that third-party lenders might actually use if we were really going to lend you money? And those rules are not really far more than that. We've already heard a comment, we may have missed something on trade payables, et cetera. And I'll just close on this point. The Secretary has said very clearly that we put these out as proposed regulations in the 385 space. We do not have a kind of stubborn pride of authorship. We may have missed things. We will have an intense comment period. We'll be listening to taxpayers. We want to do things that are both right from a policy point of view and also minimize burdens on companies. But I think to have sat there and watched this phenomenon go forward at the cost of US taxpayers, shifting these burdens from from one group of taxpayers to those of us who are left behind, whether it's small businesses or individuals, did not seem to us to be a responsible thing to do. And that's our 385. That's where we are on inversions. So I look forward to our debates. I want to thank you very much for your attention today, and appreciate you having me.